All right, good morning. Welcome to the Judicial Proceedings Committee. Today is Friday, March 11th. We have 11 bills on our voting list, and we are going to start off with Senate Bill 662, Senator Zucker. So I'll switch over to Council Heather.
This bill requires the comptroller to distribute funds from the state's unclaimed property to the Access to Counsel and Eviction Special Fund. There is an amendment in your packet. So with the bill as amended, it would be $14 million. And then also, instead of this only applying to 2023 fiscal year, it would apply to 2024.
Thank you. Does the bill specify how long a person's property is abandoned? Like, what is the time frame before this property is determined abandoned and then it's able to use to go into a special fund?
So the bill's not altering the abandoned fund property the way that process.
That's not this one.
No.
So it's not altering the way the fund works. It's
Oh, okay.
already in the unclaimed fund.
Okay. Never mind then.
Okay.
Second. So this is part of the, I know Senator Hedelman's bill went out, and that you can't project what that's going to bear. So we worked with B&T, to Senator Cassidy's point, to make sure that things are more tiered, so we have a better picture of what the funding scheme is going to look like for the next couple of years. So they plussed up the amount in this bill to ensure that you can fund. Yeah.
And postponed to the year because we're addressing through the budget, FY23.
Correct. All right, so there's been a motion for favorable. It's been seconded. Is everyone okay? Awesome. All right, the bill passes with amendment. Next, we'll go to Senator Wallstreicher. Do you want to talk about number 2 or 614?
Jamie says it's okay.
Okay.
Yeah,
Got it.
so we can move it.
All right, so Council? Is it Jamie?
This bill repeals the specific list of substances included in Schedules 1 through 5 of the Maryland Controlled Substances Act, and instead incorporates by reference controlled dangerous substances added to any Schedule 1 through 5 by MDH, CDS scheduled by the federal government on any Schedule 1 through 5 unless MDH objects, and CDS analogs as defined and designated under existing statute. So currently, the state has a very long list that gets updated every year, or almost every year, of substances that have been changed on the federal controlled substances list. The state usually conforms to that. This effectively takes out that long list of substances in statute and puts it with MDH.
I dropped chemistry in college, so I move favorable on this bill. I always never understood we were voting on these long chemical compounds that no one understands, so I move favorable on this bill.
And then Heather will go to you for Senate Bill 897.
Okay.
Senate Bill 568 prohibits overdose information reported by an emergency medical service or EMS provider or by the Maryland Institute of Emergency Medical Service Systems or MEMS from being obtained by a law enforcement officer as part of a criminal investigation or prosecution. The requirement that a healthcare provider disclose a medical record without authorization of a person of interest to grand juries, prosecution agencies, or law enforcement agencies, or their agents or employees to further an investigation or prosecution following compulsory process is subject to the limitations on patient overdose information reported by an EMS provider or MEMS being used for or obtained by a law enforcement officer as part of a criminal investigation or prosecution. So currently, these records are prohibited from being used in a criminal investigation or prosecution, what the bill is doing is saying that not only can it not be used for that, it also can't be obtained by a law enforcement officer as part of a criminal investigation or prosecution.
So I have a question. Let's say you're, have a driver that is in a fatal accident, right? And the driver is, in the hospital, knocked out of the scene. They are in the hospital immediately. And so there's none of the regulations apply. But currently, a police officer could petition the court and get that blood level, alcohol level, the BAC from that blood, and be able to move on about prosecuting. Is what this law doing, is that taking that away?
No, these are overdose reports. That statute provides that EMS and MEMS can use a specific data platform to facilitate overdose detection mapping, and basically the information from that report is what we're talking about. It's
So that's fine, and that's what I want to clarify, is it's just the overdoses. It doesn't affect any of the other times that the court would be moving to get that information from the hospital.
well, if it's in the report, it's the reports that we're talking about. So if there's some other source for that information, then no. But that what's outside of the report is not affected by this.
Okay.
So I don't see an amendment in here because the sponsor submitted an amendment, and then Baltimore City was favorable with an amendment.
We did not have anything submitted to the committee, but let me just double check.
It's on the, if you look at, you can see his amendment, it's under, yeah, it's in there.
All right, we're gonna hold it then to read out if that's
So this bill, there is an amendment in your packet. So the bill as amended repeals the authorization for a court to order that an individual be committed to a correctional facility for non-payment of a fine. So instead, the court can convert the fine to community service, reduce the fine amount to an amount that the court determines the defendant is able to pay, and then also modify the fine to be paid in installments. It strikes the rest of the bill. Yes. So these amendments were submitted to the judiciary to review. They are no longer opposed to the bill as amended. And to be clear, with this bill, when it says fine, it's referring to a monetary penalty under a statute for a crime. It's not dealing with restitution. It's also not dealing with a civil judgment. It's just a fine.
A dollar amount on the fine? Like, is there? Like
So
a
this bill does
ceiling?
not deal with that. So in this bill, if a defendant is unable to pay, the court can consider
Okay, okay.
why
I got
and
it, I
then
got it.
alter
Okay,
the
thank you.
fine.
I understand.
So currently what the court can do is they can reduce the fine amount. And then alternatively, if the court makes certain findings, it can also say that 1 day of imprisonment is equal to $10 of working off the fine capped at specified amounts. So this bill repeals the ability to incarcerate an individual for inability to pay a fine.
Make a motion to just adopt the amendments. Work off of that. All right, second. All right, is everyone okay with that? Further discussion? Yeah. Senator Castley.
The court says community service, 20 hours of community service, and they don't even do that. Now, do they have the option of saying, well, now you're going to go ahead and do time, Or if they don't do community services, can they just order more community services?
So, no, under this bill, they would not be able to then incarcerate an individual for not doing the community service. The court, it can order that the fines be collected as you would a civil judgment, under a different provision under the code. This bill's not altering that. But the individual could not be incarcerated if incarceration was not ordered at the time it was imposed. And they could not then increase that amount either.
Yeah, so, I mean, look, if you had the money to pay, you probably just pay, you don't do community services anyway. So you're doing this because you can't pay or you're limited. So sending it to collections does no good anyway. So we order community services and you don't do them, and then you order more community services or something, you don't do them, and there really is there's no remedy here for someone who,
So from my experience, at least with like the restitution system, having dealt with it personally and having overseen it, and we've tried to fix it, the restitution repayment system, I know this is not that.
Yeah.
Is pathetic. I mean, they don't pay it. People, it's like a third maybe we're paying it. Even we've tried all these efforts. I gotta imagine on these fines and fees, it's probably, do we know statistically how many people are even paying these?
I don't have that information. I don't.
I mean, my
Just right.
sense, at least from the restitution system, is people treat it like a joke and don't pay it, don't participate, which is a shame. And we've tried to fix it, and I gotta imagine if these fees and fines are the same way, if you remove, it's kinda like the driving without suspended. When you make that a non-jailable, even though you don't really wanna jail people for that, when you remove that, threat, or you remove any consequences from it, they're not gonna be able to, they're not gonna take it serious. And yeah, it's just a fine, but you know what? It's a fine because they committed a criminal penalty. They did something as part of their punishment. And without being able to enforce that, they're basically gonna get off without a punishment.
So you're still gonna be subject to garnishment. I mean, and so if you start working, the normal collections process will still go. What this does is it said you can't ever go to jail for a fine.
I don't know how effective our
Well, let me just finish.
our collection
One thing
agency is.
I mean, the judiciary has withdrawn their opposition to this, so it's not of paramount concern to them, fiscally at least. So.
I just think you're going from a system where they probably didn't get incarcerated, they got a fine, they didn't pay the fine, and now you order them community service, they don't show up at that, so they're gonna get nothing, and we're believing that this, collection agency will go and get them, which, I don't know, I'd have doubts about that, because we had huge problems with our collection agency. All these systems, collecting money, the collection agencies, we had huge problems with them all in the past, so.
I think it's terrible public policy to have someone subject to incarceration for not paying a court fee.
No, I don't disagree that we want people locked up for that. On the other hand, if I give you community services, you're not gonna do that anyway, and your solution is, well, they can garnish their wages. But that's very difficult to garnish wages. You can only do a certain percentage, depending, at a certain level, you get nothing. And, above that, it takes forever and ever. I mean, yeah, if the person is making 50 grand or so, then yeah, it's meaningful. But if you can't, then, if they're not, then it's really not a solution. I mean, you basically have a set of laws where some people can just walk around it. I mean, people who have responsible jobs, those laws are for them, but the laws aren't for people who don't have responsible jobs. And if you're self-employed, if you do other things for income, you're immune to all this stuff. So I have a problem with that, but, okay, thank you.
Just one last question.
Sure.
Would these not been that the court would have put these fines in many cases in lieu of incarceration?
So when the penalty, so the way this bill works is the judge can order the days or the fine. If the court does say, I'm giving you a fine in lieu of 30 days in prison, if you do not pay the fine, then you can be incarcerated for 30 days. That is part of the penalty. What this bill does is that the court would not be able to retroactively go back and alter it. So the court could not then find, you didn't pay the $500 fee, days were not imposed at that time, so I'm going to convert the $500 fine at this time to imprisonment.
So all these misdemeanors we do, we always have, we just had one the other day, which is like 2 years or $5,000, right? So the court comes in, and we look at these things, you know, no one's actually to get that time. No one's getting the year, no one's getting the 2 years on some of these things. So the court comes in and says, I'm gonna give you the $5,000. All right, you came in, you had this, let's take the bill we had last week on the firearm offenses. All right, you did this misdemeanor, you were in possession of a ghost gun or whatever. I'm gonna give you the $5,000 fine. Does this say that if this guy doesn't pay the fine, then they're not able to come back and reincarcerate him?
I think the way the bill as drafted is that the court could not retroactively amend the sentence that they impose. If, yes.
And that, I have a major problem with that, because you gotta look at most of the misdemeanors we have here, there's a monetary penalty and an incarceration penalty. I think we know that when we're doing it, they're not getting, many of these are small, you know, these minor misdemeanors, a lot of them 6 months and things like that, they're getting the penalty. And so if you're saying now that they pay the fine, but the vast majority are, and then there's no way to go back and incarcerate, they don't even pay that, the fine is there so that you're not incarcerating them. Like, that's the, you know, you've committed a crime, you've done something. And some of these could be serious, too. What if these are more serious offenses? I mean, felonies carry carries fines and stuff.
I mean, if it's more serious, it's less likely that you're gonna get fines in lieu of incarceration if it's more serious. But your point's well
less
taken.
likely.
Your point's well taken with the other ones, fines in lieu of incarceration. That's more well taken. Serious stuff you're not gonna get, just fines. Okay.
Mr. Chair, can I ask a question? So, I'm not sure if this just addresses globally all fines, but there's a myriad of different ways fines can occur. It can occur that you go to court, you go to traffic court or whatever, and you have a fine, you don't pay it. It could also be that you have probation and you have to pay fines and court costs. That's encompassed in this as well, right?
So as defined in the subtitle, fine does not include court costs. So
But
it's
but
just,
it could be a fine associated with, that the judge imposes because you've gone to court. It could be a probation fine, right? Fine and
yeah, so fine is just defined as a monetary penalty prescribed by a statute or ordinance for a crime. So if you have a traffic offense, that's a penalty up to $500, that would be the fine. But then if you go to court and then there's the $500 fine plus court costs that are dealt with, that would not be touched.
Thank you. So I was just trying to get at the fact that you have like a two-tiered fine system. You have the fine, that's just there's no probationary thing, and then you have like the probation. So I would just suggest that if there's a fine associated with probation, there's always an opportunity for the court to make a different decision if there's a violation because you didn't pay the fine, even though in a practical reality, very few judges ever impose incarceration because someone didn't pay a fine. They usually just end it, terminate it, fines deemed uncollectible, and whatever. But in those cases, the money goes to the Central Bureau of Collections. And so that would not change here, right?
I actually think that if you don't pay like your supervision fee or a fine like that, I think it's under the technical matrix and you're only gonna get 15 days. Is that not, if you're under probation, you're not paying your fines and stuff? I think it's a 15-day, so you're not gonna get your sentence.
You make a good point on this. All right. We'll go back to the drawing board on this. All right, now we'll go on to, actually, can we go back to Senator McRae? Senate Bill 568, you've got the amendment, right?
Yeah. So the amendment for Senate Bill 568, this is the overdose reporting bill. On page 3, in line 2, where it says that it can't be accessed by a law enforcement officer, by a law enforcement officer is being struck, and instead it says from an overdose patient's medical record. So let me just read that all together for you. So it would say overdose information reported by EMS under subsection A of this section or by memes under D of this section may not be used for a criminal investigation or prosecution or obtained from an overdose patient's medical records as part of a criminal investigation or prosecution.
Senator Cassidy.
Now we get back to the, this only applies to, this is overdose information reported by an emergency medical services provider under Section A. Section A says emergency medical provider or a law enforcement officer who treats, releases, or transports to a medical facility, individual experience a suspected or actual overdose may report the incident using appropriate information technology. So seems to me that under this bill, if the law enforcement officer, I'm on the side of the road in my car, I have drunk and consumed so much alcohol that I've passed out, I'm overdosed on alcohol after smashing 5 cars. So they call the emergency medical services providers who now do take me in. They realize that I've got the worst blood alcohol, just showed a death, and now they would come back and prosecute me. That those medical records would not be admissible under this provision.
The information reported in the overdose detection mapping application that the statute is covering would not be.
Well, this says your medical records.
So if
The
that was
the amendment
from-
you just,
I see what you're saying, because that's not your medical records, that's the overdose detection mapping report, like.
Right, that
why is
part I'm
in your
fine with.
medical records?
okay, but now we're adding in these medical, you can't obtain it. You just added in all the medical records, so.
Right.
I mean, a normal DUI, he's not gonna call the ambulance, he's just gonna arrest me because I'm not that sick, but now they arrest me and call the ambulance because you're really far off, and now they take you in and they do the blood analysis. None of that's discoverable because it's in the medical records.
Can you read the amendment again?
Right, so it would say that overdose information reported by EMS under subsection A or by memes under subsection D. So that's the information reported by those entities in connection with those detection mapping applications may not be, 1, used for a criminal investigation or prosecution, or 2, obtained from an overdose patient's medical records as part of a criminal investigation or prosecution. So that suggests that it's in the overdose patient's medical records that are now off limits, not the reported
Memes report.
information. Right.
Right, and that's my problem with the amendment, is it goes too far. Because I have no problem with these memes reports, to have an overdose, you call for the overdose, they responded for the overdose. But now you go in for the medical records that say you can't get the DUI records for the prosecution of the person who just killed 3 people, but was still alive himself because he was so drunk, but nearly died himself from overdose. Now those records aren't coming in either. I think the amendment goes too far.
Can I ask, yeah, is this related at all to DUI? 'Cause I thought it's only about drugs, different from alcohol, as distinct from alcohol.
Specified.
Just says an overdose.
It just says an overdose.
But it makes references to opioid overdose, and
DUI isn't just alcohol.
It's under the influence of anything.
under the influence of anything.
It could be a mixture, it could be one or the other.
We're on the amendment, yeah, we're on the amendment, go ahead.
Just following up with what Senator Cassidy asked, I was thinking the same thing. So you know that when there's an accident and you're passed out or you go or taken to the hospital, they have an automatic right to do the blood alcohol test on you. Would this affect that?
No, I wouldn't read it that way because the provisions that allow a law enforcement officer to request or require substance testing. That's in the transportation article, and that doesn't appear to be affected by this, no.
So maybe, was there a motion for the amendment? You want to press it or you withdraw?
Getting at this information that people are concerned about, just not through the medical record.
Just not through that overdose information report information.
Amended. Continue with discussion. Is everyone okay? All right, so the motion's for favorable. It's been seconded. Is everyone okay? Okay. All right. We need to go back to Senate Bill 662. B&T wants to change the sunset date? Okay, what, can you explain?
B&T has requested that we push the sunset date back by 6 months, so the new sunset date would be June 30th, 2024, instead of July 1st, or sorry, excuse me, December 31st, 2023.
So the motion is to recommit the bill, to reconsider the vote with the bill and the amendments passed to add another amendment. So is that everyone okay recommitting the bill? Reconsidering the vote? Okay. 662.
That is the access to funding for.
It's pushing back the effective date. All right, so the motion is to add that amendment. Everyone's okay? All right, it's been seconded. Right. Now the bill's before you with the amendments. Is everyone okay recording the same vote as last time? Excellent. All right, now we'll go on to Senate Bill 613. Senator Wallstreicher, you want to chime in?
Thank you, Mr. Chairman. As everyone recalls, this is the bill related to non-consensual towing. I want to thank both the advocates for the bill and as well as those who have expressed concern for getting together recently related to this bill to try to work things out. After talking with members of the committee, I'm convinced that we have the votes here to pass this bill clean. But nonetheless, I think it's better if the parties were to work things out. The House subcommittee is meeting on Tuesday. They too believe that the parties need to get together before that House subcommittee meets to work everything out. And so, Mr. Chairman, even though we have the votes to pass this bill, what I'd like to do is hold it until our voting session next Wednesday and move it on Wednesday under any circumstances.
Got it. Excellent. All right. As for held, it's held till Wednesday. All right, now, actually, let's go to Josh, Senate Bill 612. And then, Josh, we're going to go to Senate Bill 668. And then, Josh, we're going to go to Senate Bill 53.
Senate Bill 612 increases penalties and points assessment for violations related to participation in racing or speed contests and prohibits a person from attending any such event as a spectator. The bill also establishes a statewide prohibition on exhibition driving on any road or private property that is used for driving by the general public, and likewise prohibits a person from attending any such engagement as a spectator. Additionally, the bill authorizes a police officer to order the towing and impounding of a vehicle that is driven in either a race or a speed contest or an exhibition driving event. There is an amendment in your packet that is number 583420/1. The amendment adds to the bill an increase in the penalty for modifying a noise abatement device on a motor vehicle so that the noise emitted by the vehicle exceeds that as originally manufactured. So currently, that violation results in a ticket for which the prepay amount is $70. The amendment would increase that fine to $200. And I would just note for the committee that the prohibition on modifying the noise abatement system is separate and distinct from the penalty for using a motor vehicle with a modified system, and the penalty for that using a motor vehicle with a modified system would remain the same as it currently is under the amendment.
So I'll speak on the amendment first, not the bill. But the amendment, I know many of you have probably received these complaints, but for me, in my district, just a lot of the street racers with modified mufflers making sounds that far exceed the decibel levels that are permissible in a county. So as opposed to going after the actual people that have this on their car, this goes to the people that are actually providing the service to put it on. I know we talked about this, Senator Watson, a little bit. So it's not gonna cause more people to be pulled over. It's not gonna cause, any sort of profiling. It just goes after the people that are actually putting the services that are being provided to put these on. So I'll speak to the amendment, not the underlying bill, but that's why I put the amendment on. I thought it was a good vehicle for this, and I thought it addressed a number of concerns that my constituents have expressed. Sure. Sure. Can we adopt the amendment first and then speak on it? Okay, so there's been a motion before, it's been seconded, are you okay adopting? I know he doesn't like the amendment, or that part of the amendment. It's on, okay. Let's go. Is everyone okay? Okay, Senator Huff is against the amendment. Senator Cassidy's against the amendment. Senator Bailey's against the amendment. I'm gonna have Senator.
Discuss it before we put it on?
We can do that, yeah.
I understand. I heard one going the other day down, a lot of, if you take, especially like these Hondas and the ones that are the little four cylinders, and they put like a muffler on there, it's really loud and it's annoying, almost sounds like a motorcycle. I get it. That said, but I'm reading this, a person may not modify the exhaust system in any way to be driven on high, in such a way that the noise emitted by the vehicle exceeds that as emitted by the vehicle as originally manufactured. Anyone that owns any sports car, almost any muffler that you put on there is going to be louder than what was originally done. When I was 16, I had a Firebird, and I put a high-performance muffler on there. Almost everybody does. It's going to be louder than as you originally put on.
We both just had the same idea. Just you could tag it to the decibel level for whatever the jurisdiction is that you're in. So there'll be an ordinance. I'm sorry. Yeah. So just it doesn't exceed the legal decibel levels of the jurisdiction you're in.
That's fine. I'm fine doing that. I think this is too broad as it's done.
We had the same idea. All right. So let's adopt the amendment and then make that amendment change.
So just to be clear, you'd be modifying the underlying prohibition, which would then also have the result of, by implication, modifying the prohibition on using the system. Because it currently, basically, it says you may not modify the system, and then you may not use a system in a way that's modified in that fashion. So it would also become, it would also have the effect of basically having the same change on the other prohibition.
Why can't you decouple the two?
You could say that the increased fine only applies when you've modified the system in a way that makes it exceed the decibel level permitted by the county.
Look, if I could speak on this,
Yeah.
I think you're okay on the decibel thing, because look, if it's that loud, it's like if I take a muffler off my car, it would be like that loud. So that's the whole idea of a muffler, is it quiets your whole exhaust system down. And so if it's that loud where, now, I don't know what the decibel level is, but you can tell. When one goes by the other night, you can hear it. But what I'm trying to do is that 90% of people that upgrade their car, it's going to be a little bit louder. But there's the level where it's like a motorcycle without a muffler or whatever. You can hear it from 10 miles away. I don't have a problem with that making an offense, or somebody can pull them over, deal with it, because the odds are their car is totally out of compliance. That said, so I'm fine with that, but I think as long as we get away from this language, louder than originally manufactured.
So I agree with you on the second part, but not the first. The way that we were trying to thread the needle here is because I don't want more people getting pulled over necessarily for
Well,
it.
you're never going to enforce it then. If you're
go
not
after-
able to pull over the really loud ones, what are you going to show up at like the little shops and try to tag them? I guess you could. Here's the problem with that though. A muffler is really easy to replace.
You can do it yourself.
People order it themselves to do it. They're just going to do it themselves.
The act of we could do that. But I just don't want people getting profiled for this. Because we talk more offline on that, but I don't want people getting profiled for it. I think the manufacturer or the service provider, the shop, that's the target.
All right, I'm fine with that.
Okay.
I put a really loud muffler in my car as a teenager, so I'm not.
Hey, I did too, and I
overeager on
had
this.
two 15-inch subs in my Honda Accord, so I get it.
Get a hole in it.
Do you want Senator Bailey?
So I have one question, Josh, or just a little follow-up. I have a drag strip in my area, you know. MIR is in my area. And there's a lot of people that have street-legal cars that then modify them the evening of that race, right? Because you definitely don't want restricted airflow when you're on the strip. And so I just wanted to make sure that what we're doing here doesn't affect those people that do have that, right? And some of them live right by the racetrack, right? They set their car up, they drive over there in the evening. I just don't want to make sure that we're all of a sudden making them criminals.
If you look at B, a person may not drive on any highway, motor vehicle with exhaust or no inflation. That's a good point. He's worried about the drag strip. If you, like, out by me, actually, they would drive out to West Virginia. At Summit Point, they've got it. So if you obviously, if you're drag racing it, you know, but isn't that covered under B, a person may not drive on a highway or state motor vehicle?
So here's my point.
I'm sorry, I'm looking
Exactly,
wrong way.
okay? I mean, we've got a lot of custom evenings, right, that are set up on the drag strip. And this is not something that people do on the, they don't go down the highway, they don't set it up right in our area like they do in a lot of jurisdictions, because we have a drag strip. They will modify their car, they'll drive over there, and they'll do their races, you know, on the strip, right? They're not endangering anybody else, they're doing it right there. I don't want to do something that if for 2 or 3 miles from their house over to the drag strip, that I make these people criminals, because if that's the case, then they're just going to go out and start dragging it wherever, right? I want to be able to say that they can go there to the strip and they can do it. They're not going to drive over there, or some of them.
Highway would not include, I don't think it would include the drag strip, but yeah, you would, if you're driving on the roads to get there, yeah, you would be prohibited from doing that, as you currently are.
Yes.
Well, no, under,
So I guess what you're saying is they keep their foot off the accelerator when they're going there, they're okay, they can just idle there?
well, technically, under the current law, if the system has been modified in a way that it can exceed the noise as originally manufactured, you're in violation of either, of using it on the road, as long as it's been modified in that way. It doesn't say, I mean, the current law doesn't refer to the decibel level allowable by the jurisdiction.
Okay.
Are people, you're saying when people are driving on the way to the tracks?
Yeah, if they have made, if the system has been modified and they're driving the car with the modified system, they are currently technically in violation of the.
So that's current law.
Correct.
Well, I mean, you know, there's a lot of people that, and maybe it's just because we have a racetrack.
Yeah.
And we know that that's where they go to do it, right? A lot of people don't, you know, not that you look away from it, but as long as they're not acting up and they use that car that's tagged to go down the road to get to the track, that's fine. That's not an issue, right? They drive them to and from. They don't have to buy a trailer. Then they get home and they pull in their garage. They set the car back up to go back to work during the week, and they take that off, right? But that's, you know, I just didn't want to do something that made it more apparent, you know, for them. Because there are people that have the financial resources to have 2 cars, one that they keep on. Yeah.
Are we only talking about cars here? Are we talking about motorcycles and other moving vehicles? How is that
It
defined?
includes all motor vehicles.
So motorcycles that are racing on the Beltway in my neck of the woods. Okay, good, thank you.
Yeah, Mr. Chair, I just want to say, in Prince George's County, we have a place called Budds Creek, which is similar to what the Senator's talking about. And,
Happens to be in St. Mary's County. But
okay, we hang out with you sometimes as well. But the point is, when these cars go to and from, I mean, no wheels are coming off the ground. There might be a slight increase in noise because they're getting there, but that's pretty much it. And I doubt that substantially goes over the decibel requirement for the county. I don't see it being an issue. I think we're good to go with not impeding what goes on at these private raceways.
Adopt the amendment, and then we'll work off the amendment to refine the language so that it's just the decibel level. Can you inline that?
Yeah, but would it be, are you modifying the entire prohibition or just what qualifies for the enhanced penalty?
What qualifies for the enhanced penalty?
Okay.
Is everyone okay with that? Yep, so the First Amendment is adopted, and then the Second Amendment, can you just read what it would say?
So on page 6 of 6 of the reprint, in the new subsection C, the current language is a person convicted of a violation of subsection A of this section is subject to a fine of $200. I believe it would say something to the effect of a person convicted of a violation of subsection A, or actually rather what would have to happen is there would have to be a new subsection B, which would say basically a person may not violate subsection A in a manner in which causes the noise by the motor vehicle, emitted by the motor vehicle to exceed, and this is another question, would the relevant decibel levels be the decibel requirement in the jurisdiction where the car is registered, or
No, where it is,
where it would be modified?
yeah.
Okay, so it'd be something to the effect of a person may not violate subsection A of this section
No, where the car physically is at the time.
of the time of modification.
No, where,
Right,
that's right, you're right.
I thought you were talking about modification too.
right. So
You can't do that under this amendment.
the current amendment increases the penalty for the modification, not for the use.
Yeah.
Yes, modification, you're right.
So it would be, a person may not violate
There's
subsection
problems with that too.
A of this section.
They're gonna find some
All right.
jurisdiction with a high decibel.
I know,
level.
I
They're
know.
gonna open a bunch of these shops up. A bunch of muffler shops gonna open up in your place.
Yeah, but what if you go to now I'm thinking, if you go to a jurisdiction that has like a really low decibel level, then the person that modified it is gonna get jammed up because like,
No, because the offense is completed where the modification takes place.
But what I'm saying is, what if you travel to a jurisdiction with a low decibel level?
They gotta respect that.
Yeah, got it, okay.
So there would be
Yeah, I know.
so a new subsection B, a person may not violate subsection A of this section in a manner which causes the noise emitted by the vehicle to exceed the maximum decibel level permitted by the jurisdiction in which the modification took place. And then the new subsection C would be a person convicted of a violation of that new subsection B is subject to the $200 fine.
Go off mic for a second.
We're on the full bill now, right? Oh, then I'll wait till the full bill.
We're gonna adopt this amendment and then table the conversation, okay, so we can move on to the list. But go ahead. We can, okay, go ahead. Go ahead. I
Well,
wanted to move on. All right.
Assuming we're gonna get back to the bill, and I don't know if Senator is in the same place, but I've been waiting to talk about the bill because my reading of it, and correct me if I'm wrong, is that the bill criminalizes the spectators in this, and that's a real problem.
I would agree with that.
I agree with that 100%. That came up on during the hearing.
So what are we gonna do about it?
I mean, if I was walking down downtown Annapolis, I saw somebody street racing, I might just out of curiosity stand there and watch it.
That's exactly right.
A lot of these times, a lot of people are attracted because they know something's going on, there's a big crowd, they might not have
Okay,
any
just give me a
thing,
second.
they're just tagging along, they're there, and then this will give the police the authority to arrest them and charge them with crimes.
Here's, I was gonna do this, so
Nobody
let's,
likes that part.
in effort to move us along, we're gonna have to address that and the amendment that we discussed. We'll get some people together to work this out before the next voting session. Okay? Sure. We're not doing the amendment.
Add in two or more, I mean, a lot of these things, any one of these things would not indicate street racing. I agree that you start adding them up, street racing, but some of these things are just skidding. It's like, I don't know, just take a look at that too. All right.
So Josh, the First Amendment's been adopted. We're gonna hold the bill, though, and we'll refine the rest of the bill.
I've got some ideas on it, get you on.
Cool.
And Josh.
Got it, yeah. We gotta get to this, though, because I get, like, dozens of emails about this every day, like. All right, we're gonna go to 668, and then we're gonna go to Senate Bill 53, okay? Josh, since the rest of the day is yours, you wanna come up here?
Senate Bill 668 renames the existing truancy reduction pilot program to be the truancy reduction and school reengagement program and expands related of the provisions related to the program. Currently, it's only authorized in certain counties, and the bill would authorize it in any county in which the circuit or county administrative judge has established a program, and to the extent that funds are provided for the program. The purposes of the program are to adjudicate cases filed with the court under Section 7301 of the Education Article, to identify the causes of truancy and school disengagement for children participating in the program, to assist the child parents or guardians, and the schools in ameliorating the causes of truancy and re-engaging the child in furthering the child's education.
Sandy. Any questions for council? Senator Watson?
Yeah. So Josh, tell me, this bill was created to deal with a capacity issue, a lack of capacity in the current programs?
No, so the program as it existed is a pilot program, which is authorized in Dorchester, Hartford, Kent, Prince George's, Somerset, Talbot, Wycomico, and Worcester counties only. And the judiciary came in and wanted to make it a statewide authorization for any county or circuit which had the funds and for which the chief administrative judge elected to set up a program in that jurisdiction.
Do we have any success statistics resulting from the pilot?
I believe there may be some in the,
I didn't see any in the committee.
yeah, if they weren't submitted by the judiciary, I don't have that information.
So we think that this is a good idea to expand it based on, what, data from other states who do this?
Yeah, I believe in the Department of Education's testimony is some national data, I believe, and the judiciary is of the opinion that the programs are working well.
And putting kids through the truancy court still exposes them to court, right?
To court, yes.
So we're going to increase the likelihood that our kids still get exposed to court, and assuming that it won't have a negative impact on them, but it'll be a positive one, helping them stay in school.
Correct. And there are, the bill does specify the specific orders that the court can make in the cases, but they are involved in court when they're in the program.
Thank you, Josh.
They did cite one study from San Antonio, which just reduced the truancy by 66%.
Yep.
And there are some footnotes at the bottom of their testimony.
I just don't like exposing our kids to court in any sense of the word, but I get it.
How are the kids referred to the program or to court? How are they selected?
So they would have to have alleged a violation of 7301 of the Education Article, which requires them to attend school. And then I don't believe,
But how does the court get aware? Like, the school then reports it to the court?
yeah, because it's a charge, it goes through the court in the first place. So the question is whether it goes through a program like this or it goes straight to the juvenile court.
Senator Sindor.
To Senator Watson's point, one would think that if you have a pilot program, there should be some data or some reporting somewhere. So, I mean, I don't know if maybe, if it's not required, maybe we should, if we're going to go in this route, maybe it should be required that there's some sort of reports that, so that we can ensure that the children are, that this is helpful to the children who are being put into this system.
So you want to add a reporting requirement to the General Assembly and the governor, or to GOCAP? Where do you want it to go?
To us.
Do you want to do it to our committees or just to the General Assembly, Judiciary and JPR?
I would say it would come to us and maybe judiciary.
Yep. Senator Watson.
In addition to that, we break it down by county.
Disaggregated by county?
Yes, and the reason why is it's nice to have data from Texas. I don't know if their demographics match ours.
Yeah.
I think that Prince George's County is very unique in its urban environment, and I think that needs to be called out. So if we do it in county, I think we have a better sense of whether this is really working or not.
To the courts.
Would they be producing it, or? I think logically, the courts are probably, the administrative office of the courts would be the ones compiling the report from that county data, and they would send it to us.
All right, so just can you read the amendment in concept and we'll adopt?
Yeah, so the amendment would it be like a one-time report, or?
Annual.
So it would add codified language to the bill requiring that likely the administrative office of the courts would, on an annual basis, submit a report to the General Assembly detailing the number of children that are involved in these programs, broken down on a county level. Could potentially include language about outcomes, though that's subjective. They could report on the outcomes for children involved in the programs, and maybe recommendations for statutory changes.
Senator Catholic.
Along the reporting line, I do note that the judiciary did respond to the OPD in their testimony. And there was a study done that was entitled Assessing School Attendance Problems, Truancy Intervention in Maryland, a synthesis of evidence from Baltimore City and Lower Eastern Shore, dated December 2011. And in that report, they did say that there was a problem, that there's limitations to this report because there's not as many people participating. Obviously, that's a problem. They have a smaller, but their conclusion was that children who have successfully completed the TRPP experience improvements in school attendance, GPA, and juvenile justice experience. So there is reporting that the courts have. It's just that they need more of these things, so they have a larger sample size to get quality. All right. Thank you.
So we'll have a larger sample size and a larger report. There you go. All right, motion to adopt the amendment. Seconded, everyone's okay? Fantastic suggestion, Senator Watson and Senator Sidnor. All right, the bill's before you as amended. There's a motion for favorable.
Second.
It's been seconded. Is everyone okay? Excellent. Okay. Now we'll go to Senate Bill 53.
Senate Bill 53, subject to a limited exception, prohibits a law enforcement officer from conducting a custodial interrogation, as that term is judicially defined, of a child until the child has consulted with an attorney and the law enforcement officer has made an effort reasonably calculated to give actual notice to the parent, guardian, or custodian of the child that the child will be interrogated. The bill establishes related requirements for custodial interrogations of a child and establishes a rebuttable presumption that a statement made by a child during a custodial interrogation is inadmissible if it is the result of a willful violation of the bill's requirements. Law enforcement officer may conduct an otherwise lawful custodial interrogation if the officer reasonably believes that the information sought is necessary to protect an individual from an imminent threat to the life of the individual, and reasonable delay to allow legal consultation would impede efforts to protect the threatened individual, and the questions posed to the child are limited in scope to address the danger to the individual. There is an amendment in your packet that is number 753022/1. This amendment changes the title of the bill to the Child Interrogation Protection Act. It modifies the exception that was discussed to the prohibition on interrogation. So the exception would now be where the law enforcement officer reasonably believes that it is necessary to protect an individual from an imminent threat of physical harm, and the questioning is limited in scope to address the threat of physical harm to the individual. And it also clarifies how the state may overcome the presumption of inadmissibility. They would be able to do so by showing by clear and convincing evidence that the statement made was made knowingly, voluntarily, and intelligently. And it also clarifies that the presumption of inadmissibility does not apply in a manner that would bar the statement from being admitted against, in a proceeding against another individual other than the child.
Discussion on the amendment. Senator Carter.
Mr. Chair, so this, the amendments that were drafted were the result of conversations amongst different parties. Myself, Senator Castley, the House sponsor, was in those meetings, also a representative from the State's Attorneys Association, and for the most part, this is language that was agreed to. I think that we've all heard the bill, we've all been hearing about the bill, and this is the third year, I believe, that I've presented the bill. We're simply affording children that are subject to the criminal justice system the same rights guaranteed under the Constitution that we afford to adults. The first step of the bill would just be that the parents would be notified. The second step would be that an attorney would be allowed to consult with the child, and then the child would then still be subject to interrogation after having consult with the attorney. And so, with all of that being said, I move favorable.
Is there a motion to adopt this? It's been seconded. Is everyone okay working off the amendment? Okay, great. Negative for the amendments. Bailey's not down on the amendments. Okay. All right, now the bill is before you as amended. Further discussion. Senator Castley.
Just, look, the discussions, there's not an agreement on this bill, just to be straight up on that one. We're changing it from juvenile to child. I mean, this thing goes up to 17, up until your 18th birthday, just, one day shy of your 18th birthday. So I think of children as elementary school children, not people that are one day shy of, they're driving and they're doing everything else in life. No, but they can lawfully engage in everything a married person does. So let's, then we move to custodial interrogation, just so we can appreciate that within the juvenile realm, that's a particularly fluid realm, because it's whether you reasonably believe that you're free to leave. A juvenile, so that's not it's not like this means, was he cuffed? Did the officer say you're under arrest? This relates a lot to what the person, the subject, believe whether they're under a custodial interrogation. So we're subject then to have statements excluded where the officer had no intent to put the person in custodial, in custody, that it was they stopped and were asking questions, responses were given. So we could end up releasing very violent criminals onto the street where in a case where an officer had no intention of violating this and was moving in good faith. Looking on page 4, this consultation, you can't even waive this. So if the officer pulls the car over and there's a gun in the front seat and there's 4 kids in the car, the officer wants to say, okay, hold on, there's a gun, you're all kids here, there's a gun on the seat, whose gun is that? He can't say that. The officer's only choice then at that point is to arrest all the juveniles in the car, all 4 of them, bring them back to the station, process them, and wait till the attorney comes in before he can even say, whose gun is that? So and now instead of having 1 arrest, we just got 4 arrests on that. On page 5, it says that law enforcement, that you can proceed if there's an imminent threat of physical harm. I don't know how the officer can establish that piece of this. He could say that there's a gun loose somewhere. How does the officer establish that it's an imminent? He can say there's a threat of harm to other people, but I'm not sure how the officer establishes that, look, there was a crime, there was a gun involved. He doesn't know where the gun is. It may be sitting in a drawer somewhere in somebody's bedroom. It doesn't present an imminent threat to anybody. It presents a threat, but not an imminent threat. So that the imminent threat language there really causes a good deal of concern. It's in there twice on the imminent threat part. And then finally, my big concern is on page 6, that this renders the evidence inadmissible in both a criminal and delinquency proceedings. I've sat here for 8 years now hearing that that the delinquency is not about punishing, that the juvenile services is totally about rehabilitation, protecting the minors, getting them the services they need. Why we would exclude statements made from a delinquency proceeding just totally escapes me. I understand the criminal proceeding, that's there to put people in jail. But why we would treat those the same, if somebody needs services, they should get the services. If they need counseling, whatever they need, the presumption is that their kids, they have problems because they need extra help. And we're saying, no, we're going to exclude this evidence. I think that's wrong. I want to get you into church by hook or by crook. I want to get you to counseling by hook or by crook. I want to get you to AA and, Alcohol Anonymous, Drug and NA Anonymous by hook or by crook. Some things, they're for the benefit of the person, and I think excluding this so that you avoid getting the child the services, the protection they need is wrong. I understand in the criminal proceeding, but not in that. So that's my problem with the amendments and the bill.
Briefly, so first I want to talk about the idea that you talked about, just the title change to child. We already define children in our law. Most aspects of our law is 18 is always the bright line point. The only area that we've changed that is when it comes to this criminal justice system. And then, of course, in the marriage bill that you all passed, where you decided that children that could be charged as adults automatically couldn't marry. So the second part of this is that nothing in this bill stops a law enforcement officer from pursuing those persons. Nothing in this, if the officer sees a gun in plain view, the officer has every right to act on that. All this is the custodial interrogation, already defined in law. If these were adults, they would have the same thing. They'd have the Miranda rights, they'd have the right to remain silent, they have a right to an attorney. All this bill does, and I just think it's important to clarify it, is make sure that the young person understands what they are doing and what their rights are after talking to an attorney. And even though the right to talk to an attorney isn't waived under the bill, there's nothing in here forcing the young person to talk to an attorney. They can say, after they've talked to the attorney, that they don't want to go forward, or they do want to go forward. So it's not an absolute bar. It's simply taking necessary precautionary measures. So that's all I want to say. And then also, in many areas of our law, we deal with imminent threat. And last year, we talked about use of force extensively. And we allow officers to have discretion as to what they perceive as an imminent threat or not an imminent threat. And so there's nothing different about that here. We trust them in other situations to determine when there's danger, when there's threat, when there's imminent threat. So I don't know why we would not still be able to trust officers to make those determinations under this bill. Thank you.
Yeah, so, even as we sit here, there's hundreds of these sort of police-child interactions, we'll let your word go for that, going on across the state. Overwhelmingly, those aren't resulting in arrests or prosecutions, but they are resulting in gathering of information that makes us have a safer community. Of course, when an officer has a discussion with a juvenile, they have no idea whether they're involved absolutely nothing or whether there's a murder case lurking just behind the scene. What this does is put a chill. It tells the cops, you can't talk to them because if you do, you might have just excluded the evidence that you don't. we're putting a terrible chill. We've already got, we sit here and we hear about the proliferation of guns on the streets. We hear about the proliferation of juveniles shooting everybody out there. The proliferation of juvenile crime, it's just run amok. And this is one more step to say to the police, pull back even more, because if the juvenile, all the juvenile has to say is, oh, I thought I was not free to leave. And now everything that you learned is now excluded from both, not just the adult court, but the juvenile court. So the officer, it's the practical application that is devastating here. It's not the theoretical application. Theoretical application is easy to make sense. You have one cop in the world, one kid in the world, and they're interacting, and take the rest of the world out of it. So, from that standpoint, it follows from the law books. But it's the practical application. It's that law of unintended consequences where we're putting one more chill of pulling the police further out of their interactions with the juveniles, and their interaction has to be one of two: shut up or arrest. That's it. Currently, you have this big gray area where they can kind of wander into it and talk to the kids and interact. But what this law says is no. Shut up or arrest. Those are your two things. And so I don't think that's where we want to be. I think we want to encourage police interacting with our juveniles. I think we want to see them talking. We've got body cameras. I had no problem with the provision of the bill that says if there's an interrogation, it's got to be on body camera. I'm fine with that. And as we're pushing body cameras out, there would then be an absolute bar. You can't come into court and say, the juvenile said to me. Where's it on the body camera? It's not there. We currently have an arrangement where every police interaction with a juvenile is recorded, and the courts can look there and watch. And each court in every case can say, that kid was intimidated. He did not, I can see from his face, he don't know what you're talking about, he's scared, and you should have shut up. And they can exclude that. That's all, we already have that. We already do that. That's there. It's, the interactions are being taped. Cops know if you're going to be talking to these kids, make sure the body camera's on. I have no problem with an absolute bar to anything coming in against a juvenile in either juvenile court or adult court if it's not recorded. But I think we need to follow with the current system that tells our judges the defendant has a right to get that tape. They're going to put that tape in, and they're going to say, Judge, look at this tape. You can see from the interaction that that child did not understand, and you should exclude that evidence, and the officer should have known better. So I look at this as it's a remedy. We've already moved beyond this problem. We've already moved beyond it because we have the body cameras. We took a huge step, and so we've really, for all practical purposes, solved this problem. And what all this is going to serve to do is chill police interactions with kids, and I don't think we want to do that. I think we want our cops talking to kids, because that's how the cop finds out about the kid who says, you know, they are dealing drugs on my street. There's a guy out there who's causing problems. There's a gun floating around. We want that interaction, and this is going to set that back, because now we're going to have, the children are going to know if the cop suspects anything of you, he's going to arrest you and hold you until the lawyer comes. I think it's a bad way to go, but thank you.
Except, I want to correct a few things. First of all, the idea that something's recorded on a body camera has nothing to do with ensuring and protecting that someone is aware of their rights. The other part of this is that what this bill also does is make sure, as everybody in this room that has children would want to have happen, to be notified when your child is taken into custody. So that's the first part. The second part is simply to allow that child to talk to a lawyer before the custodial interrogation ensues. I think, Senator Castley, you continually talk about interactions. This bill has nothing to do with interactions. This is what is already defined in law as a custodial interrogation, which is a point in a criminal process when it's clear that someone is a suspect and everything that they say at that point can and will be used against them. And then I finally want to say that you also indicated that this would stop someone from being able to give information to an officer. Not at all, because we actually, in the conversations we had, we put protections in the bill where even if there's a violation of the law, of the right, of the child's rights, the state still can come back and say, listen, there's a rebuttable presumption. The state has a right to come back and try to rebut the presumption that the stuff is inadmissible, and it's not inadmissible against anyone except the actual child. So if there's other people out in the street doing things, the child can still give that information. And it's not about, because that's not self-incrimination. This is the same thing that adults get, that we say, look, even adults, like, these encounters are so inherently coercive, adults have to have these rights. So it just defies logic that we wouldn't extend that to a child who we know's brains are not at the same level as adults. So I don't want to go back and forth, but I don't think that you gave an accurate depiction when you talk about all interactions and when you equate a body camera to protecting someone's rights.
Thank you, Mr. Chair. First of all, if the bill passes, I certainly would like to be a co-sponsor on it. But I do have a question for the bill's sponsor. On bill page 6 of 7, when it's speaking about the use of body-worn camera, it speaks to, it says, in a jurisdiction that has adopted, and then there's another subsection for jurisdictions that have not adopted the use of body-worn digital recordings. What I was curious, when we're speaking about jurisdictions, are we talking about counties? I'm assuming we're talking about counties because, I mean, I guess in some jurisdictions, some counties or localities, schools may have policies against body cams coming into the schools. So I'm just curious how if there's that contradiction where the jurisdiction itself has the body-worn cameras, but maybe the school has a policy against those officers coming in to the school with them. How do we? Was that discussed at all?
No, but I would imagine that it would be the same as would apply. This, like, that's not this, like, this bill doesn't affect anything about that. Like, currently, what if there's that conflict, it could be the case. Like, I don't see that this bill affects the potential conflict between an officer's body-worn camera and a school policy.
Okay. And the second question I had, because you were intimately involved in this, is there a duty on the law enforcement officer to be honest under this bill? Because I know from a bill hearing that we had last year, there was a bunch of debate about.
Actually, I remember in the hearing, I think Judge Karoum proposed that as an amendment, but that is not something that we added to the bill, no. If you wanted to make an amendment, we could entertain it.
I certainly would be interested in because I think most of us, and especially children, would assume that if a law enforcement officer is saying something, that law enforcement officer is being honest. So I think there's. I certainly think that would be a good thing to do, and would like to entertain that.
I think that's just another reason why it's so important that the child have a consultation with an attorney, because these are the very types of things an attorney can explain to the child prior to the interrogation. The attorney can explain that the officer has great latitude in what they say and that everything they say may or may not be factual. So I agree with you, but I would say that that just solidifies why we need that attorney consultation.
Thank you, Mr. Chair. So there are elements of this bill that I can support. The idea that parents ought to be notified is an obvious give. But let me just give you an example and ask how the bill would affect it. So you've got a bunch of high school kids, 16-year-olds, in the gym, and say 16 of them, and the gym teacher goes to the bathroom, and when he returns to the gym, one of them has been stabbed and is lying on the floor bleeding out. And he's rushed to the hospital in an ambulance, and you've got, 15 kids left. Would this bill require, and of course the police are going to be called in, would this bill require all 15 kids without any interrogation at all to be taken to the police station and incarcerated in some place, one of those rooms with the one-way mirrors, cells, whatever, until lawyers can show up to represent them? And wouldn't it be the case that a lawyer couldn't represent more than one because the lawyer could end up having a conflict? Wouldn't you have to get 16 different lawyers to represent the kids while they're in jail?
Well, first, the easier part, I think, is the issue about lawyers and numbers of lawyers and conflicts. First of all, the bill doesn't specify that a lawyer has to be physically present. The consultation can happen by phone or over video recording or the like. But the second issue is the same conflict law that applies every place else would still apply, whereas the privilege against conflict is the right of the child. And so I would argue or suggest that the lawyer would have the same obligation to explain to the child that in representing more than one, there could be a conflict, and the child has the right to waive that conflict once being made aware of it. Again, in any situation now, if there's these other 15 young people around, they may or may not be determined to be suspects and taken into a custodial interrogation. If it's just a general investigation, there is no right to an attorney.
Until you start to ask questions, right? Until
Well,
you
no.
start to ask questions, every one of the 15 is a suspect.
No, because right now, under current law, when it comes to investigation versus custodial interrogation, there's clear indications once someone becomes a suspect, and a law enforcement officer then has that duty to Mirandize those person. So if Miranda doesn't kick in under any other situation, it wouldn't kick in now. It would only kick in once that person is deemed to be a suspect, and it's time, and the officer knows that before I go further, I got to advise this person of the rights. It wouldn't change.
I've read enough Agatha Christie novels. So you've got a closed room, you've got a dead body, you've got 15 people. It seems to me every one of them is a suspect, right?
Well, it depends on what.
Until you
it
start the
depends on what
examination and can eliminate
It may
people.
seem to you, but it really depends on what the officer believes at that time, and whether the officer chooses to treat them each as suspects, or whether the officer's just doing a general crime scene investigation, which doesn't make everyone, right now. So right now,
Well, wait a
if
minute,
there's a
isn't-
dead body in the street and the officer has 15 people around, the officer does not Mirandize all of those people. The officer asks questions, and only once those questions lead the officer to a conclusion that someone is a suspect, that is the point when when they take them into custody, it becomes a custodial
In
interrogation.
my hypothetical, once the officer gets to the gym, my guess is he's going to tell each one of the 15 boys remaining in the gym, do not leave. You cannot leave the gym, right? Because one of them did it. Well, that's another possibility. Okay. Anyway, I think you understand the hypothetical I've raised.
So a lot of your hypotheticals and Senator Cassidy's, is talking about the gray area of that interaction, all turns on what the definition of custody is. And so, obviously, we've got Miranda and Miranda's progeny. And so I'll just have counsel go over what that definition looks like, and if you.
Custodial interrogation is what we need to
Yeah,
define.
and if we need to be more prescriptive. So, yeah, yes, I understand. But let's, Josh, I'd like him to kind of just give us a level set based on that understanding so we can move from there, because that's what everything we've been talking about for the last 10 minutes centers on.
Just to be clear, custodial interrogation is what we need I think is what we need a definition for.
Currently,
That's
the bill,
custody.
right, the bill uses the judicial definition, which in Miranda is essentially, it's two-pronged, it's custody and interrogation. So custody is when, under all the circumstances, someone reasonably believes they are not free to leave. And interrogation is when they're being asked questions which are designed to elicit an incriminating response. So on the custody piece, it's a totality of the circumstances kind of test. And it's difficult to say in any given hypothetical that's an absolutely yes or no answer. And normally courts would take into account, who the person, if it's a juvenile, it's a little bit of a different analysis. It would take into account the special circumstances that involved an officer in the school, but it's really impossible to say with a specific hypothetical that, yes, that definitely is, or yes, it definitely is not.
In my hypothetical, suppose the school resource officer immediately arrives in the gym and tells everybody, stay here, no one leave this room, we're calling in the police, which would seem to me would be a logical thing to happen. Wouldn't that be therefore, wouldn't they all be in custody at that point?
It definitely weighs heavily in favor of finding that, yes.
Yeah, okay.
Okay, that was my concern, because just to answer Senator West's question, the current law, FYI, is that if they take someone into custody, the officer shall immediately notify or cause to be notified the child's parents. So that's actually the current law right now. But that was exactly my scenario. Because if you look at it, it grabs law enforcement means 7-1501 of the education article, so that is your SROs. So if they go up into a school, there's a bad assault, and they tell the kid, don't go anywhere, stay right here, and they start asking questions, I agree. I think under what he just read, that falls under that. I guess my question, though, is imminent threat. What is the definition of that? Because we use that a lot in the education. Actually, that came up on another debate we had, but what is the definition of imminent threat?
I mean, it is going to be judicially defined, and the exception is fairly similar to the public safety exception of Miranda, so this is speculation, but I would think that if it ended up in court, courts would largely use that as a framework. So I know the most common scenarios where that applies is, when there's a gun and the police don't know where the gun is, or there's another suspect at large. Those are the kinds of situations that often fall into that exception. But it would be a judicially defined term.
I guess that gives me a lot of pause, because you've got, I just don't feel comfortable unless we know define what that means to pass something, and then how's a police officer supposed to know what that means if we're just saying, well, a judge will figure it out? How's an SRO in a school supposed to know what imminent threat means? If it's not defined legislatively by us, do we have a judicial definition of this? Okay.
So I understand what the amendment is getting at and support the idea here. So this comes from the Quarles case, which is a U.S. Supreme Court case. So Quarles uses the phrase threat to public safety. That's the phrase that Quarles uses. So that's the judicial.
Which is different than imminent threat. Much different.
Much different.
Much.
Imminent means immediate.
Yeah. Threat to public safety is very broad. Imminent is immediate. That's a huge difference between those two terms. An imminent threat wouldn't be if you had a very bad assault. I don't know how that would fall under imminent threat versus you got a school shooter. Yeah, obviously that falls under imminent threat. But if you had a potential even first degree assault, if the act is done and over, how's there I don't know.
But I think that, I think that it matters, and I think that the reason that it should be imminent threat is because the issue is not that the person cannot be interrogated. The issue is there a reason to bypass what we would put into law that they have to follow these protocols in a custodial interrogation? If there's an imminent threat, then one would argue, no, they would not have to. But if there's not an imminent threat, then there's no urgency, there's no reason why the officer would need to proceed without following the law. So that there is a reason that imminent threat should be in the bill.
The challenge is you're not going to know there's an imminent threat until you talk, and that's what we've chilled here is we don't have the talk. Senator Carter refers to it's a point in time. She talks about it only occurs at the point in time when when they're in custody. The problem is, as counsel explained, it's not a point. It's not when the cuffs are on. It's not when he says, put your hands against the car and spread your feet. It's not. Especially in the case of children, it's not when the officer says, I intended to arrest him. That's certainly a factor, but the more overriding is, when did they feel like they couldn't leave? They felt like they couldn't leave when the principal walked in the gym and said, don't go anywhere. You all stay right here. I'm putting three other teachers around here. Somebody's been seriously injured here. You all were here. The teacher was out. Now you are all in custody. Juveniles are social creatures. They do go in packs. That's normal. It's healthy. They're supposed to. So police interact not with a person. They interact with groups of people. And what we're creating here is, whatever your social circle is, when the police officer comes up and says, you kids, hold on, stop. There was a report of a person being stabbed down here. I just looked around. I see you kids running away. Stop right here. I don't know what's going on here, but just everybody here, stop. I have to take you all in now. I can't talk to you because I clearly told you to stop, you're now in custody, I'm gonna interrogate you to figure out what is going on here. Let's just, you're all under arrest, we're gonna take you all down, we're gonna wait for your parents to come, we're gonna wait for the attorneys to come, and then we'll start sorting this out. Meanwhile, that you've used all those police resources to do that, of course, you didn't realize there was another couple of people 2 streets over because you weren't able to quickly discount this group of juveniles, which you had to put all your police resources on, who could have quickly explained what they were up to, but you didn't give them a chance to because they couldn't even waive it. You couldn't even waive the discussion. So I had to assume they were all guilty of stabbing that person. They may have said, hey, we were running because somebody was shooting at us and they're around the corner. No, we can't talk. Freeze everything. We got to get this. And I was not suggesting that we not give the juveniles their rights. That's not the point. The point, what I'm saying with the video, it's not give them the Miranda rights or show a video. No. It's that the Miranda rights are on the video. The concern here is that a juvenile, if I'm 14, I may understand as much as a 40-year-old person what you're saying about you have a right to an attorney, all the other stuff. 40-year-old people have watched many more TV shows. They understand how that goes. The 15-year-old kid might not. It's that in giving those rights, they are on video. And now we are in a position where you can actually have a judge actually watching this kid's face as he's getting his Miranda rights. And that judge can independently determine that he's not getting it. I can see from his face. I don't care what you were saying. He's lost in the sauce. Or, no, look, he gets it. He understands it. I can see his demeanor. I get that he gets it. So that's the point with the video. It's not that it's video or Miranda rights. So, and going to Senator West's example, I mean, he really does capture it. That we want adults to be able to come in and quickly dismiss people and try to identify this, but we're not going to. We're really creating a situation where everybody has to be arrested in every case. It's the wrong way to go. The technology has made the problem you're trying to address has been largely corrected by technology, but we're going to go ahead with a system that chills interactions between law enforcement and schools and juveniles and God, in this particular time with the rampant violence, especially amongst the juveniles, this is not where we want to go. We should be, it's not a good step. Thank you.
Are you suggesting, either you or Senator West, that if the officers come on the scene and there's someone that is falling to the ground in a stabbing and there's people walking away, the officer would not assess that as an imminent threat, as an emergency situation? Is that your suggestion? Because I actually believe an officer would believe that this is a situation where there's potential imminent threat. It's up to the officer to make that assessment, but I can't imagine there's anybody walking or running away. And what more likely would happen, because it happens all the time, there's something that happens in the neighborhood, there's all these people standing around. Certainly, those are not custodial interrogations, those are investigatory questions. Then, once that's done, and there is a reason to believe someone might be a suspect, like maybe 14 people stand around to talk to the officer and say what they saw, and one runs away, then of course that person that's running away often might rise to the level of becoming a suspect. I'm just saying that officers are trained to assess these situations, and if there's somebody falling to the ground in a stabbing and people walking away, I believe there's very few officers on the planet that would not see that as an imminent threat.
Thank you, Mr. Chairman. I mean, the other thing is both of your hypotheticals presume that there's no other adult around and that this interaction is happening in a vacuum with just a police officer. So in the example of the gym, it's like you have the entire staff of the school and the teachers and the gym teacher are going to come in and say, what in the world happened here? And there's nothing in here that precludes any interaction between the police officer and the adults. So in terms of chilling the communication, I don't think that this does that.
So, I mean, I'm just looking at the dictionary definition of imminent is ready to take place, happening soon. So if something bad has already happened, it wouldn't fall under this. And so what I would suggest, we already have the amendment, I suggest striking the term imminent and at least voting on that. Because I have a, and just say threat to public safety, because my concern is with the violence and stuff happening right now in schools and I mean, we are having tons of incidents at Frederick County. We had another bad incident this week. So, I just have a real concern with saying, well, these incidents and stuff happening, we're gonna have this chilling effect on the police. They have to figure out if it's imminent or not, and we don't really define it. It's not really known, and the dictionary definition doesn't seem to
I
help.
don't agree, because I think that we trust police every single day to determine whether something's an imminent threat.
In all due respect, right, my life is all, I like to talk about the same thing.
I got you,
and
but
then-
he asked what I thought.
Oh.
Go ahead. No, go ahead.
So I'm going to say that I totally agree with that perspective, and that was what I was going to bring up. And the reason is, in today's day and age, when we're going out there as a police officer and you show up to a school, right, one thing that has occurred much more recent, and we talk to our sheriffs, no matter what, the gangs are in our schools. Right? And the fact is, we want our SROs to be communicating with these officers, and we want them to be on a first-name basis with them when something happens. If there's a beat down or something else that is going to occur against another group, we want to stop it. And I think that the fact is, if it's a threat to public safety, I think that is something that an SRO or any officer that responds to the scene is going to be able to understand in one of these situations. And as the parent of one of these children that's in the school, I think that's a good idea.
To get to this bill. So we got to go to floor, but we're coming back after floor to do this. Okay. I want to get out of here too, but we got to. Yeah. Okay, we'll come. Okay. All right, we'll come back after floor.